backpacking?
Because
historically, before the ICC was created, there was already ad hoc international tribunals for ex-Yugoslavia and for Rwanda. And the ICC Rome Statute was built in part on the experience that was already started before with the international tribunals for ex-Yugoslavia and for Rwanda, because they have already established statutes and rules and regulations and so on. And the states, when they were negotiating the Rome Statute, the treaty that created the ICC, they learned from this experience and added some elements eventually to improve on it. So one of the important elements that were added is actually the creation of a trust fund for victims. The idea is if someone is found guilty and reparations should be ordered to the victims, if this someone who is guilty does not have enough financial resources, or we didn't find hidden financial resources, then who should pay the reparations? That's why the states created a trust fund dedicated for the victims that gathers contributions and donations in order to implement the reparations orders. Another element that is also important that was added with the Rome Statute, so that is different from the others, is the participation of victims. So in the ICC, inside the courtroom, there is a possibility for victims to be heard through a legal representative and sometimes directly. Few of them can be present before the judges to explain what they have been living and going through and the impact of the crimes on their lives. Just explaining what is the impact on their lives, what are their hopes from justice. A witness is a different matter, and we can discuss that later. A witness testifies to give an information that can be useful for the judges to decide on something, and a witness is normally called by either party or by the court itself. The ICC is thought from the beginning to be permanent, so to continue for the future, and also not to be bound by a specific conflict. So it's not created for ex-Yugoslavia or for Rwanda or for other countries. It's created with the aim of being international and hopefully in the future universal, maybe, if we can convince all the states to join in. But that means that by definition, it's not looking at one region. It's not looking at one conflict, at one country. And that allows it both this kind of geographical expansion and the permanent nature of the court allows it to pre-exist to a certain conflict and hopefully can have a deterrent effect to the extent that is possible on the conflict. It also means that it is not waiting the end of a conflict so that the guys who won would establish a tribunal for the guys who lost. It also means that we do not need, at each time there is serious conflict, to create a new institution and to take the time to create a new institution and gather the political will and the financial resources and the human resources to create it. Here there is already an institution that has been created and is designed to be permanent. So there's a lot of advantages why it would be good to have a permanent international criminal court. The creation of the ICC by a treaty and not as part of the UN means that not all the nations are parties, are members of the ICC. To become a state party, they need to ratify the Rome Statute. So it's every state who has the possibility to choose whether or not to be part of the ICC. Currently, we have 123 states that are parties to the Rome Statute. When a state becomes party to the court, that means that this state has given the ICC authority to investigate certain crimes, if these crimes are committed on its territories by anyone, even by non-nationals. But also, the state has given the ICC authority to investigate crimes committed by the citizens of the state, even outside of its own territories. So that means that in principle, we have this jurisdiction, the authority to investigate the crimes when they are committed on the territories or by citizens of states that are parties to the Rome Statute, the 123 states. But is there a possibility to expand this jurisdiction? Because it doesn't cover all the conflicts, and some conflicts can be very serious. And sometimes the process of ratification can be complicated and long. So there is a possibility for the governments, if they want, they can make a declaration, what we call declaration under Article 12.3 of the Rome Statute, giving the ICC jurisdiction without going through the process of ratification. If certain conflicts are serious enough to be a threat to the word peace and security, then the Security Council can create an obligation under Chapter 7 of the UN. And this chapter allows the Security Council to make binding obligations over the states members to the United Nations. Because they have chosen to be part of the UN, then such a decision by the Security Council is not a violation of their sovereignty, because they have given the Security Council this power. So this is the only way to impose the ICC jurisdiction in a situation where the country itself is not party and is not willing to accept the ICC jurisdiction. This is an exception, it's not the general rule, and this exception has been used twice to date. One related to Libya, and the other one is related to Darfur in Sudan. This is how we can have jurisdiction over a certain conflict. That doesn't mean that when we have jurisdiction, the ICC would be superior to the national tribunals. The national tribunals retain the primary responsibility. So these are important principles that the ICC is built on, that it's built on a treaty. So normally it's the state who decides to accept the ICC jurisdiction either by ratifying or by making a declaration, with one exception, which is when there is Security Council resolution under Chapter 7. And the principle of complementarity. The ICC does not replace the national tribunals. It can only intervene when the national courts are not willing or not able to genuinely conduct the investigations. The fact that a country has withdrawn does not remove the ICC authority to investigate. So the system has been built in a way that when a crime is under the ICC jurisdiction at the moment that the crime was committed, it remains under the ICC jurisdiction even if a country withdrew in the future. So that's why whatever happens at the time when Philippines was a state party remains under the ICC jurisdiction, even if the cases eventually, as resulting from the investigation, are brought after the withdrawal became effective. So the ICC retains the jurisdiction over crimes that may have happened when Burundi was still a state party. The withdrawal in the future does not affect retroactively the crimes. It only prevents the ICC from investigating if crimes are committed after the withdrawal became effective eventually. As for the investigations themselves, the investigation is, as I just mentioned, confidential. We have to respect this confidentiality in order to protect the sources of the information and the possible witnesses. So we do not discuss the matters that are at the phase of the investigations. As for the ICC, there is a clear legal framework, which is the ICC Rome Statute, specifically Part 9 of the ICC Rome Statute, that specifies the possibilities of cooperation, the obligations of cooperation, the possibilities of discussing with the courts at certain issues, and so on, between the states and the ICC. And South Africa, as a state that is party to the ICC Rome Statute, we believe has the obligation to cooperate with the ICC within the framework of Part 9 of the Rome Statute. Every prosecutor in the world has to decide on which cases he will be presenting to the judges. It is totally impossible to investigate all the crimes, specifically in a long conflict like Darfur. And the prosecutor, when focusing on certain elements of the investigation, is also concentrating the resources that he has to have meaningful results. So there is legal criteria, but after that there is also the policy of the prosecutor, how to use the limited resources that he has within his office to gather enough evidence to present a case to the judges. So maybe the prosecutor has other evidence, but they are not, in his view, sufficient enough to convince the judges. So that's why a case has to be focused on what the prosecutor believes that he has enough evidence to bring it to the judges and to convince them beyond any reasonable doubt with this evidence. So again, I don't know if there are other evidence within that the prosecutor has, but I know that the prosecutor believes that this case, with this evidence that he has is strong enough to be before the judges, and that's how a prosecutor would decide which cases to bring to the judges. The trial itself has to be done with the suspect present. But the pre-trial, there is a possibility to ask for the judges to conduct in absentia, which has not been used before at the ICC. A confirmation of charges is a kind of filter. It allows the prosecutor, it allows the judges to know if the prosecutor's evidence are strong enough to go to a trial phase, or if the case should stop at the pre-trial level. So it's filtering the cases. And if a case goes to a trial, with which charges, which counts? Because maybe the prosecutor is presenting 12 charges, but only 10 of them eventually are strong enough in the view of the judges to go to a trial. So it filters which cases go and based on which counts, which charges. And that is the phase that the prosecutor office is asking to be conducted in absentia for Mr. Kony. In the views of the prosecutor, this would show some progress with the case. It will allow some, maybe some testimonies, some evidence that are kept to be used and show determination, and allows the judges to decide if this should be maintained and moved to a trial level or not. So this is the purpose of the confirmation of charges hearing, and why eventually it is possible to conduct it in absentia. If Ukraine joins the Rome Statute in the future, that would have several consequences that are not directly related to the investigation because it's already open. They are related possibly to the cooperation, because it facilitates the cooperation when you are already a state party. It facilitates also the principle of complementarity, because there are national proceedings that are then created in order to match the national law with the international treaty that has been eventually ratified. It also gives a signal from Ukraine to the commitment to the international justice and international criminal justice specifically. If Ukraine becomes a state party, then Ukraine will be having the full rights and obligations of state parties, including the rights of election of judges and of future prosecutors, of proposing amendments to the statute, and of course the obligation that goes with that of cooperation and financing and so on.